You struggle with ADHD, is that correct?
Correct, among many other
All right, so are
health
you,
issues.
all right, so here's what I'm going to ask you to do today. I'm going to call your case in just a minute. I want you to come up with your three top arguments, and you're going to tell them to me, and then we're going to try to organize your arguments around those three top things. Now, you've got to remember that you've got 30 minutes. Why? Because Ms. Lungbitz needs time to respond. So you cannot just talk at me nonstop for an hour. It's not going to happen today. All right. So let's call your case then. Okay, we're here indeed, Lemon Nisos versus Dina Zanan. We're here on a motion to modify / correct order, motion to reconsider that was filed by Mr. Michael Lemnisos. Mr. Lemnisos let the court know at the last hearing that he has a disability for which he was requiring some accommodation. The last time we let him have the floor and talk as much as he wanted, I will say his thought process became highly disorganized. For that reason, today we are going to ask him to give us his top three arguments and try to keep his court arguments structured around those top three. So, Mr. Lemnisos, what are your top three issues that you want to talk to us about today?
As far as issues are concerned, there's mainly one issue,
What's that?
Which is the modification of the order after it was rendered by Your Honor orally in the courtroom, and after a signed draft was made by both parties.
Okay, so
and
you stop
presented.
there. You stop there. See, that's all I need you to. We're high level right now. Ms.
Okay.
Lungbitz hasn't even announced yet. So you
Okay.
kind of have to kind of get it together a little bit. What's your
Okay.
second big issue you want to talk to me about?
It depends if Your Honor going to take in consideration in your decision today the answer that the counsel filed to my motion. Then I will have to respond to that.
Okay, that's your second issue. What's your third issue?
Third issue is
No, there isn't. There's two. Okay, stop. Now, I'm going to call, let's see, we've already called it. Ms. Lungbitz, would you please make your announcement?
Yes, Gina Lungwitz, Domestic Violence Clinic, University of Texas School of Law, here for Dima Alzak-Non.
Okay, thank you, Ms. Lungbitz. Do you have one of your students with you today?
I don't. They've all graduated.
All right. Well, it's always a joy to have your students here, and we look forward to bringing in more next year so that they can have an opportunity to see court proceedings and get their sea legs in the court, so to speak. All right. With that, Mr. Lemnisos, I started the clock. You've got 30 minutes. First issue is modification of the order. All right. Please try to organize your thoughts, and you may proceed.
Thank you, Your Honor. My thoughts are pretty much everything that is mentioned in my motion. So I'm just gonna, for the sake of complying with your instructions, I'm gonna try to just reiterate that. Just a quick point here is I am not in a position to correct, object, or even mention the disadvantage that people in my position in general are at in this court. The main obstacle in my way basically is the fact that the system, the central docket system, imposes that every time I need to present something to the court, I mean, let alone my health issues or disabilities or what have you, the court and the law hold me as a pro se for the same standards as it holds counsel, a certified attorney. Yet at the same time, it does not grant me neither the privileges nor the stature or whatever it is that Your Honor would like to call. So to begin with, I'm at a big disadvantage. So the least I would ask for is that I would be treated fairly and justly and without bias. The bias against people.
May I just say this? May I just say this, Mr. Lemnisos?
Yes.
It is my full intention, as it always has been with you and with all litigants, to treat you justly and fairly. Yes, I will say pro ses are held to the same standard as counsel. However, in this court, we do attempt to give you some assistance, as I have today, by telling you at the start of this hearing how to organize your argument, which you ignored. So you have had that opportunity, but nonetheless, I reassure you that in all things, I will treat you justly and fairly. And with that, you may proceed into your argument.
I can't ask for anything more, Your Honor. I would like to ask first, before I proceed, whether Your Honor is going to consider the answer. So do I need to address that also, or not?
You may address whatever you think is important.
Okay, so in this case, I will start with the order itself, the main issue here. Since the start of this case, which is extremely complicated and convoluted, it involves two other cases. I had received, I can very clearly, assure that on the record, that I was not treated fairly, and I did not receive any fair treatment or opportunity to defend myself or to present my case to the court. Now, with all the events that happened, the opposing counsel, since she started her involvement in my situation back in May last year, held nothing. Your Honor got practically mad at me last time for even though I didn't call her a liar, I did call what she presents to the court as lies.
Okay, here's the situation. The reason why I get angry with that is because you are held to some standard, and ad hominem attacks against opposing counsel, they're inappropriate. So when you're using a word like lies and liar, you need to be very cautious on that. All right. That's why I don't think I got mad at you, but I'm just telling you that's inappropriate as it is today. So please proceed, but keep in mind that those types of attacks are not appropriate in the court. All right. You may proceed.
I understand, Your Honor. However, my major problem here is just like in this answer that she filed today, since she started her involvement in my case, she has presented her entire conduct is a subject for a different venue and a different issue. However, the point that I was making is that even though Your Honor just mentioned now that we are held to the same standards, I don't see that we are held to the same standard if the opposing counsel, because of her stature or her relationship with
it's not her stature or her relationship. It's that she's opposing counsel and she's an officer of the court. So we treat her with respect as an individual. We don't attack her personally. It's not that because of her stature or her relationship. You need to get that straight. Now let's be clear here. You've used 7 minutes and we still haven't gotten into the body of your motion. You told me how you're held at a disadvantage or treated and you've attempted to attack Ms. Lundwitz. That's all you've done. And I don't know what you're here for so far. So please focus as I asked you to at the beginning, and let's hear what you're here on because you're running out of time.
Okay. I try to help myself by setting a timer in front of me. Okay, so back to the main issue, which is the order. I needed that order. The court issued, and that's why I brought these points, several orders, and I'm not talking one or two, that are plain wrong and does not comply with the law, does not is not correct, at least, and at the minimum, I do have the right to challenge those. Now, we're not talking about trivial orders here and there. We're talking about some serious issues such as the esteemed professor of law uses the law clearly and blatantly to her advantage, wherever. I mean, just a small example, whenever a certain law applies to her needs.
See, we're getting off track again. And we're not, but we are. You need to tell me what's wrong with the order. We're back on casting aspersions on opposing counsel. What is wrong with the order? That's what we're here on.
The wrong with the order, Your Honor, is I need to challenge all these orders that were issued and challenge the so-called final decree of divorce, because this is not a divorce case and shouldn't have been. In order to do that, and because of the severity of the injustice that I have received and the compiling wrong orders over wrong orders by this court, I have the means that I can go to is a writ of mandamus. In order to do that, as explained to Your Honor in the last session, I did not attend the so-called final hearing on the divorce because, and I explained to the judge, I did not, as the esteemed professor claimed to the court, that I just took off or I did not show up. I did show up, but I did not show up and I did not announce ready for a final decree of divorce. I showed up because I was forced by this court and by the improper communication between the counsel into waiting to the very last minute to hear my motion for continuance, even though my motion for continuance has a very, very compelling argument and reasons. Now, I'm left to the point where the final decree was issued, even though without my presence. So my next step was to file for finding of fact and conclusion of law. Again, the court did not provide not a single fact or evidence upon which it based its, again, so-called final decree of divorce, which is the least, I mean, without putting yourself in a, at least I can call it savage. There's nothing less than that I can call it. Having said that, with my limited resources, that was mainly my status, mainly aggravated by the actions of the opposing counsel. Of course, officially, it's the action of my ex-wife, but in reality, it's the counsel who is doing all this, starting from filing the frivolous suit, providing misleading information to the court, which I called previously with a poor choice of words, lies. However, that does not change the fact that she presented misleading information and mistruth to the court. Based on that, she received a favorable judgment. Now, the entire process that the opposing counsel did is explained in different motions that was presented to the court. I predicted what's going to happen, and that is the reason why I was fighting this so hard. But I can probably, I'm not a lawyer, and there is no miracle on earth can make me a lawyer within this short time. But even said miracle happened, I still cannot face. I might learn the law, I might learn the research, but I cannot learn how to oppose such conduct of the counsel. What can I do? That led us, the entire thing, this order that Your Honor signed is the last straw. That practically did, I don't know, it's just practically destroyed any hope that I might have to really get some form of justice or fair treatment. There was an order. I argued my motion. I explained to the court in my motion as well as in my oral argument. As hard as it was, I tried. I need those transcripts to challenge these orders through a writ of mandamus rather than an ordinary appeal. An ordinary appeal is okay when I'm challenging only the so-called final decree of divorce. I am challenging the entire process from A to Z with each and every single order that was issued in this court. And subsequently, a wrong order is passed, and then more order accumulated on top of it, and we reached to the point. And there's no need. I mean, if Your Honor would grace me with 5 or 10 minutes, I don't know if you did or did not read the counsel's response. That shows the true and real conduct. The counsel, more than once, in the very first time that I requested this, which was back in
okay. You've used half of your time. Just be aware of that. You've already 15 minutes. So you need to wrap up. You've got only 15 more. Okay, you're done. And we got to switch to Ms. Lungwitz.
Okay, it's in front of me. Now, Ms. Lungwitz, on this particular issue, more than once stated to the court that she has no stand or no position whether I do or do not get the fee for the transcript waived. Now, she stated that in the very first time that applied, which was a judge's corner back last year. In Your Honor's court last time, she reiterated the same, both orally and in writing, that she has no position. She does not oppose me getting the transcript. Me getting the transcript is my only means. I did not participate in that court, in that session. because I did not want to acknowledge that this is a divorce case. This is not a divorce case, as it was announced on the document sheet, as it was the final order issued in it. All these I don't know what to call it better than a legal salad that happened, grabbing something from here, something from there, just throwing everything together. And I am given with all my limitation and all my on top of it, my disability and inability to behave and conduct myself as a lawyer in this court, let alone a professor of law. I didn't do anything to get myself in this position. I do need to have my say. I need the court to hear me. I need to.
We're sitting here now listening, Mr. Lemnisos. We are sitting here. You've got my undivided attention.
Yes, ma'am.
Okay, so it's not that we are not letting you have your say. You've got.
Your Honor. Excuse me, Your Honor. This is my other major problem is I'm constantly misunderstood. Just like what happened with Your Honor last time when I was trying to say that Judge De La did not have knowledge or did not have anything in his hand to show him that there was a divorce. And you took it, of course, naturally, as I was trying to insult the competence of Judge De La. Then I had to go through hoops in order to explain myself. So I do have this problem. Please take that in consideration. I try as much as I can. I do speak 5 languages, but still English is not my first language. So sometimes it does take me a little bit to, especially under stress, to choose the right words. However, the intention to disrespect or insult anybody in this court or in this system, including Ms. Longwitz, is not present on my side. I came to you with this motion because I need that. And what I was trying to say, it was not directed to this very court, not Your Honor. I wasn't saying, Your Honor, I need you to hear me. I was just saying in general. My case was heard by several judges in several motions, and neither of them, before we got in, Ms. Longwitz, the professor at law, until this moment, more than a year, used me and my family and my son and my agony and my tragedy as a teaching tool for her students, and I still did not mind that. But to get to the point where not even for a second, we're going to finish today. Your Honor is going to go to your home and she is going to go to her home. You're going to get to hug your children and your grandchildren, and she will too. And here comes my third problem with my ADHD. I am unable to behave, control my emotions in the presence of the court, not because I'm a violent person, but because I am in agony. The picture you see under my profile marks the last day I have seen my boy. August 30th, 2023. With no court orders. My boy was taken away from me without court orders, without any, there we comes to the lies again. Nothing. This case is not about was not about my child, the case of the protective order. When I couldn't get my child legally back home after he was kidnapped by his mother, then I had to file the Sapser case. Now, I'm not going to go into the details, but just going to tell you, Your Honor, I have received nothing but aggression, disadvantage, bias, prejudice, and in several occasions, it was blatant, flagrant. I mean, there's nothing that can be, I mean, it's not even covered by some legal, text or context, or if you will, just, like that. We're going to deny you your motion because you did not, just a quick just a quick read to each and every motion or response that was filed by Ms. Langwitz will show Your Honor and show the court, and I would like this statement to be on the record. Ms. Langwitz, until this very day, did not argue, did not defend or act at all in any issue or any matter based on the merit, just like the answer that she supplied the court today. You can look at it and see. What does she say? Does she claim that I shouldn't ask for the modification? No. Is she saying that, you know, I shouldn't get the record? No. What she's saying simply, the court shouldn't do this. The court shouldn't do that because the court lost its plenary power. Now, I'm not, I have to use common sense before I use the legal loophole that she jumps through to come up with these concoctions, if you will. Bottom line, I explained myself to Your Honor, and I tried as hard as I did. Of course, I did not succeed. Just to give Your Honor a small idea about what is going on here. What is going on? What's the situation? But no time on earth with, you know, within these restrictions and within my abilities will allow me to do so. There's so much misconduct, so much convoluting circumstances, so much people, so many moving parts that unless a person who is hopefully a fair judge in this wants to, you know, get to know each and every these little details, they won't be able to treat me fairly or judge fairly. Now I am in a position that I have to go to the higher court. Okay. Now I can, and I did file a notice of appeal already, simply because I have to. Hadn't I filed that, the court...
You have 5 minutes. You have 5 minutes. So just letting you know the time.
Thank you. So bottom line, I have filed already the notice of appeal. So the issue of whether I do get or not get the transcript for free is not really the main issue. The issue here is by this addition to this, well, I don't know. I really don't. And I can't claim to know whether Your Honor did add this on your own or whether it was proposed to you after the fact, because I sent her, according to Your Honor's instructions. Your Honor instructed her, Ms. Langwitz, to draft 3 orders. Order granting me that the motion to approve the statement and the motion to waive. And Your Honor even argued with me whether I really need to or not to, if you remember, appeal all these orders. So it was clear to the court, what do I need from this motion? By the law, I don't need to file a motion with the court to get the transcript fee waived for the ordinary appeal. However, ordinary appeal will restrict me to appealing the final decree of divorce. I need to get a writ of mandamus to correct the injustice that was done before we got to the point of a final decree. There was severe errors and injustice that was done. This case transferred into a divorce case without any legal basis. The court conducted its final hearing and issued its final decree of divorce without, I am confident 100%, but I do need an evidence in my hand to show that the information was presented to the court is false. The process that led to the hearing of the so-called final hearing on a divorce is wrong and it's illegal. And for that, I need that evidence. I did not participate, so I do not have evidence. I requested finding of facts and conclusion of law. The court did not bother with anything. Court simply just signed whatever Ms. Longwitz provided. Just like the court signed whatever Ms. Longwitz put in her so-called proposed final decree or proposed disposition. I filed, after receiving the not so clear, not so present even facts, finding of facts and conclusion of law, I filed for amended and modified and additional. Again, the court did not respond, but the opposing counsel provided, it's not necessary. Now, it's not necessary for me to know why, on what basis did this court find me married, when the court states that it found that the proper documents was filed and there is no document to be filed as to marriage. Then, you know, I need to know, I need to show the court something that this information is false. All that pushed me for the need to file for a writ of mandamus. In order for me to do that, I do need the transcripts. And that's why I filed this motion for the very first time. And then I filed it again with Your Honor. Again, at that time, while Ms. Longwitz stated that she doesn't have a position, yet she filed an answer stating that the court shouldn't grant me that because that order is not a final order. Okay, so we were forced to wait for the final order. Same thing happened with Judge Meacham. Judge Meacham issued an order telling me that I cannot file for dismissal of the divorce case. Why? Under what law? I asked for finding of fact and conclusion of law. You can't have that. Sorry. This is not a final order. The stage was set by Ms. Longwitz from A to Z. It went meticulously with the court blessing down the road.
All right,
do need
Mr.
that.
Lemney, you've now run out of time.
Okay.
It's now Ms. Longwitz's turn. All right.
I still have a minute and a half.
No, you're done. All right, we'll get back to you. Ms. Longwitz, what else do you have for us today?
Just a couple things, Judge. My understanding of what was set for today was the motion filed by Mr. Lemnisos on April 29th, asking the court to correct the order that the court signed on April 17th, that he was objecting to the language that the court added, the language that's set out in blue. There are two reasons why the court probably shouldn't rule at all. The first reason is that the court has lost plenary power. Under 329BE of the Texas Rules of Civil Procedure, the court had plenary power until 30 days after it denied the motion for new trial. That happened on April 17th. So on May 17th, the court lost plenary power and so doesn't have power to hear further orders or further motions or have further hearings in this case. The second reason is, regardless of whether the court had plenary power or not, the issue is moot. Mr. Lemnisos has filed a notice of appeal. I've received notice of that, I believe, on May 23rd. The Court of Appeals gave him a cause number, and that's what the additional language the court added said, that any court reporter who is asked to prepare a transcript does not need to comply until provided with the cause number for an appeal. And there has been an appeal filed, and there is a cause number. And I'm not going to take much of the court's time on this, but I do want to say that in my 34 years of practicing law, I have never been to more hearings in a case than I have in this case. Hearings set by Mr. Lemnisos over and over again. The court has, many different judges have given him a lot of time because each time he says he hasn't been heard. That's all I have.
It sounds like you do have a cause number now. So we're kind of in a different situation. What's going on with you in this thing?
In this thing, Your Honor, I had to file the notice of appeal because it was the last day. After I filed the motion for a new trial, which Your Honor denied, it's extended the plenary power of the court to 90 days. And that was the date I filed the notice of appeal. It's just a precaution, so I don't default on that date and lose, which is what Ms. Longwitz wishes for me to do. May I respond real quick
Yes,
to what she said?
briefly.
Briefly, okay. As far as the plenary power, Your Honor, I mean, the main reason here is my issue is why this language was added after the honorable judge.
Because it has to be that way. Mr. Lamnesos, understand
Okay,
how many litigants we have come through here.
I understand.
We have people who will appeal things
I understand.
and not even show up in court. Can you imagine that? But
I
that's what
can,
happens.
and
We
I've
have
seen a lot.
parents. Listen to me. We have parents who will not even come to try to keep a relationship going with their children. They won't even come to court, but they'll appeal it. So we have to have some regulations and guidelines in place.
I understand.
Not personal to you, right? Not personal to you. These are the rules, and that's why the rules exist. So you need to understand that. Now,
I
what else
understand.
do you have to say to me?
What I was trying to say, Your Honor, is I understood this fact before I even applied. However, I explained to the honorable judge that I needed to, in order to face all these wrongful orders, I needed to go the route, even though it's an action by the appellate court, it's still it's not a it still needs the exact same record. I I can only get relief by writ of mandamus in order to correct all these orders. So I had to file the notice of appeal. Now, the reason for filing this motion to begin with is for that little ambiguity in the law where it does not mention that the writ of mandamus entitled the litigant to get the transcript fee waived. And that's why I mentioned that. And that's why I even mentioned that orally in front of Your Honor and also in writing in my motion. So as far as this motion goes, I had to file the appeal only because it was the last day, and if I did not file, I will lose my chance to appeal. So I filed the notice of appeal as a precaution. However, my intention is still, I do need to attack all these orders, not a single order, which is what available in the ordinary appeal. Now, to the point of Ms. Longwitz, her plenary power, the plenary power does not cover this post-judgment orders. I'm not asking in this motion, I'm not addressing the final judgment, which is the center point of the court plenary power. And I'm not asking, this is a post judgment motion that was filed timely, properly, and it was set. This is another point where the esteemed professor mentioned in that I failed to set it. I did not fail, but for some reason the court staff, the court administration office, saw it's proper that they do not let me know, and I did specifically tell them that this need to be heard by the Honorable Azullah because it's her order. And they said, okay. And because of the docket system, central docket system, I won't know which honorable judge is going to be set until the very last minute, like few minutes before the court. So that's number two. And last point to Ms. Longwitz, in her 34 years, she has never attended a case. This is the kind of information, misleading information, that I was referring to that she presented to the court. Ms. Longwitz states this statement, yet she does not state that it was her who caused all these. She she is chastising me and asking the court to take a position against me because I'm defending myself against her aggression. I did not file for anything other than filing for the custody of my child. Every time I was filing, I don't know if it's appropriate, it's not appropriate, I'm not going to say it, but just tell the court the gist of it. She kills me with my own weapons, and then she cleans her hands with my own shirts, and then she asks the court to make me pay for the dry cleaning of my shirt. That's what she did, and that's all not a false claim or an angry statement. That's facts within the court's hand, within your Honor hands. And that's all that I'm asking. I'm asking that the proper procedure or the common sense, this has improper communication all over it between Ms. Longwitz and the court staff. Because the Honorable Judge yourself did not even mention any, even though I argued this before you, and I did explain why, and Your Honor did tell me back that, you know, all these records and the cost and what have you, all that was mentioned. And I, at the time, explained to Your Honor that I don't need, for ordinary appeal, I don't need to waste the court time and file a motion and get an order. I needed it because I want to file for a writ of mandamus. I did not want to file an ordinary appeal. So Ms. Longwitz states she doesn't have a position orally and in writing. Your Honor, tell her or her student at the time to draft 3 orders, 2 orders denying my motion for new trial and my motion to stay or motion for default, set aside default judgment, and the motion granted me. She does not do that. She drafts 2 orders that's suitable for her, which are the denial, leaving me with having to draft that order. And I presented per your instructions to her, and she signed it. She signed it, and she reiterated that she does not have a position. Where did this all of a sudden came, this extreme opposition that she did not challenge my status? She did not say, no, he's not indigenous. He's not, he doesn't have money to pay. She did not go the legal route. In the surface, she has no objection. In reality, I get shocked by, after she signed the order, the drafted order, I signed it. We presented to the Honorable Judge. I get this very specific. And this, just to tell you, Honor, that's my last statement, the very exact language that this paragraph contained is the same exact language that Judge Crump's assistants, executive assistants. Oh, no, sorry. Reporter. She took it on herself. She took it on herself to contact the entire reporters that I requested the transcript from and use the exact same language. And that's why I am extremely concerned of improper communication between Ms. Longwitz and the court staff. Not to mention the fact that after Your Honor explained to me and I explained in your Honor presence, what do I need this for?
I just,
all of a sudden,
didn't I just tell you? Stop. Didn't I just tell you the reason why we do that? We do that in all cases because if someone just comes in and says, yeah, maybe I'd like to take an appeal, prepare a transcript, I don't have any money. It takes hours for us to do that, hours for our court reporter to do it. And sometimes people don't even get appellate numbers. That's why the language is in there. So we have to have that language. It's got nothing to do. I don't even know if Ms. Longwitz would know how to communicate directly with our court reporters. I don't know, but it's got nothing to do with that. It's because, as I told you, people will come up here. Sometimes they won't show up in court even to defend their rights. They won't even be here, but then they appeal the decision of the court. So we need to know that there's some seriousness before we start providing free transcripts. Hours of work go into those. All right. All right,
I
are
didn't
you
get any
done?
serious, Your
Are you
Honor.
done?
Just one final statement. I just want to reiterate that I did not need this for the Court of Appeal. I still need it. I mean, had that been said during the session when Your Honor rendered your order, your oral order, I would have argued that right then and there. And I did argue, even though Your Honor didn't mention any of that stuff. I did argue it. The fact that this addition was after, I mean, this is what I'm concerned about. I just want to know why. Why after the opposing counsel, myself, and Your Honor's oral, I'm not arguing with Your Honor whether should or should not. I'm saying Your Honor heard my argument, issued the order nonetheless. Yet after the fact, after she signed it, after I signed it, we presented it, then it was added. And again, the exact same language that the Judge Crump reporter used it in an email that she took it on herself to distribute among all. Specifically, any reporter does not need to comply unless you receive an appeal. That's what got me into saying this. As far as improper communication with between Miss Longwitz and the court staff and even some of the judges, that's a subject for a totally different.
I'm going to take real issue with you saying there's been improper communication with Ms. Longwitz. That's, again, I've cautioned you not to step over that line. All right, so here's what we're going to do today.
Yes.
I do think that Ms. Longwitz has made the correct point that there's no new rulings we can make because the court has lost plenary power. Mr. Lamnisos, I will grant you relief and provide findings of fact and conclusions of law on the motion for new trial. Ms. Longwitz, we don't mind taking a crack at those and then distributing them to you all, or you can do the opposite. In other words, the draftsmanship on it. But that's what we can do today. Ms. Longwitz, let me hear from you.
I had not seen a request for findings of fact and conclusions of law, but if are we granting an oral motion? Because we did that for the trial. And there are findings of fact and conclusions of law for that.
This is the motion for new trial, which I don't know technically that we need them on that. I don't know technically that we do. We probably don't. It's not something we typically, but he did file them on the request on April the 29th regarding for new trial.
And so my response to that was that the court didn't hear any evidence that day. Nobody was sworn in. It was pure argument. And I don't know what facts can be found based on no evidence.
All right.
I mean, Your Honor, just one question, please, Your Honor, so I can understand, if you would, please.
It's so helpful for me to hear from Ms. Longwitz. Just a moment, Mr. Lamnisos. I feel like you've had a lot of court time. You've been with Judge Crump, you've been with Judge DeLiato, you've been with Judge Meacham, and you've been with me, and there's probably some others. Yes. But sometimes it's just a wall of information that we're trying to climb with you. Right. So would you please, just for a moment, let's let Ms. Longwitz have some response so I can try to figure out the posture of what's going on.
At that hearing on the motion for new trial, there was a lot of argument. Mr. Lamnisos made a significant argument. We made an argument, but there was never any evidence offered. There was never any testimony. He wasn't sworn in as a witness to offer testimony. And on May the 2nd, the court denied his request for findings of fact and conclusions of law for that reason.
Yeah, because there was nothing new at that. And as I said, it's typically not something we do provide. I'm trying to kind of give him something because obviously we've had an awful lot of information come at us. But I hear you. So, what we were looking at was just, it's going to be a reiteration of the underlying judgment. Typically with motion for new trial, we grant them or deny them. That's it. There's no findings of fact, conclusions of law, especially when it's just an oral motion. So that's kind of what we're toying with a little bit, just because it does appear to be going up on appeal. But the only thing that would be mentioned would be a reiteration of the original judgment, because there was evidence as that. And as you point out, there was not evidence at on the motion for new trial. you
I
know.
beg your honor, the
Just
court
a moment,
already.
Mr. Lemney. So I need a minute here. I need a minute here. I'm trying to help you, but I need a moment of just no words from you, okay? Um, so yeah, the facts we just don't be on why the judgment was appropriate, I guess, is the main thing. I don't know. We'll have to think about it some. Let me hear from you, Ms. Longboots.
Well, and I'm trying to find them here, but the court there are March the 20th.
Mm-hmm.
The court issued findings of fact and conclusions of law
On the original.
on the on the trial.
Did
And
I
so,
refresh my recollection? Did I issue those, or was that a previous judge?
no, that was Judge Crump.
Judge Crump who
She
issued them.
heard the trial. Yeah, we had like an afternoon and a morning of testimony that we put on,
Mm-hmm.
and she made findings of fact and conclusions of law based on that.
Mm-hmm.
And then he filed the motion for a new trial, and there was a hearing, but there was no evidence. So I don't see any facts that could be
I hear
found.
what you're saying. Let me look in. I'm going to have to look into that a little bit more. I tend to agree with you. We're trying to give him something here for his time. But it may be that we can't do it because, as you point out, there was no evidence. There were no facts. There was no evidence submitted. There was no there were no witnesses. And there's already been some finding of facts, conclusions of law. So yeah, so what we were thinking was just the basic, the court finds on February 5th that the court denied petitioner's motion for continuance, refused to participate in final trial, and voluntarily left. So that's kind of the basic. That's all there is. So let us look into that some. We're trying to just not create more work for anybody, but just be very careful because it's unusual. I don't know that we've ever had it before that I can recall. Someone requesting findings of fact, conclusions of law on a motion for a new trial. Typically, it's the final judgment. And I must admit, that's an area that I have not dug into because we don't usually get those requests. So we'll look into it. There's no reason to be overly concerned. The court has lost plenary power on issuing other orders today. All right, Mr. Lamnisos, we're going to give you the last word, and then we need to move on to other cases. Okay?
Okay, Your Honor, thank you so much for your graciousness. The question I wanted to ask, actually, although I can't ask the court or the professor for a legal advice, but if you could only correct, I mean, my understanding for finding of facts and conclusion of law is on what evidence did the court base its judgment? And the conclusion of law is what law did the honorable judge base their finding of facts or judgment? What law was applied or correlated with this judgment? So that is my understanding. And my question to Your Honor, that was it. Like, isn't that what a finding of fact and conclusion of law? I mean, if the court issues such a judgment,
the situation is this: you did not come to the divorce hearing. What I understood is you walked out, and so I can't.
because there shouldn't be
But
divorce hearing.
stop. But
Yes,
when I'm reviewing a motion for new trial, you're making that. I'm looking at the order. That's what I have. I'm not. There weren't new witnesses. Wasn't new evidence. It was just exactly what Judge Crump looked at, and you already got findings of fact and conclusions of law on
I
those.
did
So
not, Your Honor.
please be aware of that. All right.
You can look at them, Your Honor, and you will find that there was absolutely nothing in there. Just reiteration of what Ms. Longwitz put in her proposed dissolution. There was absolutely no mention to any evidence, any testimony, anything, nothing. And that is what I needed to challenge the so-called final order on divorce. Now, the other issue is when Ms. Longwitz, what Your Honor mentioned, that what I was trying to say when you asked me to give you a moment is just that if Your Honor is willing to reconsider or have a look at these two motions, whether to set aside default judgment or
see, I
motion
don't
for a
have
new
plenary
trial.
power. This is what Ms. Longwitz is saying. I have lost plenary power.
I understand.
Only thing I could still do potentially for you, and I'm trying to do something for you, are the findings of fact and conclusions of law. Now, that's what
You
I'm
already
trying to
issued
do,
an
and I'm
order.
not, no, I'm not sure that's appropriate. Okay? All right, so you've got 5 minutes. Please wrap up, and then we need to go into other cases, Mr. Lamnisos.
Mr. Lamnisos, you need to unmute. And as a reminder, the court reporter cannot take a record when two people are talking at the same time, Mr. Lamnisos.
Thank you. I'm trying very hard, trust me. What I was trying to say, Your Honor, as far as the plenary power, I am not, the plenary power is concerned with the final judgment on the case. And I'm not asking the court today to issue a new order, hear a new motion, or argue the final order. I'm merely asking the court to correct the order because that additional paragraph, practically for all intents and purposes, render the order void and unnecessary or moot or whatever you want to call it. I did not need an order to get the transcript for ordinary appeal. I needed it because the law is not clear as far as writ of mandamus that it should be dealt with as an ordinary appeal. And as far as the issuance of finding of fact and conclusion of law Your Honor already issued that. So, I mean, if that's what's going to contain, I don't see the need to waste Your Honor time with that.
So okay, yes. Are you withdrawing that request then?
I did not. I mean,
you just said I don't know, there's no reason to waste my time with it. My question is, are you withdrawing that request?
Your Honor, I'm talking right now about you just mentioned that the finding of fact and conclusion of law for the new trial, Your Honor already signed an order saying that there are no finding of fact and conclusion of law.
Right.
And that's exactly, thank you so very much. This word or this sentence is worth $2 million for me. Thank you. It does not look right. And that is my issue with this whole situation. Nothing looks right.
All right, so we've got 3 minutes left, Mr. Lamnisos. We've given you the floor quite a bit today.
Thank you so much.
Anything else by way of reply?
I don't have anything else, Judge.
All right, very good. Thank you both for being here this morning. We're going to have our morning break of 15 minutes. Ms. Lungbitz, Mr. Lamnisos, you may be excused. Have a good rest of the day. The court will be on a brief recess. We'll come back in 15 minutes. Please be mindful that if you've got the microphone on, we can hear what you say in here. So you might want to turn your microphone off. All right. Thank you both. Have a wonderful day.
So
goodbye.
We're still in the
May be excused.
We should be back, right?
You're done. You are done for the day. Goodbye.
Oh, we're done for the day.
Yes, we are done for the day. Goodbye.
Okay. Thank you. Thank you, Anne.
So we are, we've had our morning break. After a fairly, I won't say contentious, but certainly very wordy hearing. We are now on to our next matter. This is Gabriel Alvarado versus Cristina Alvarado. We're here on a motion to compel. The parties had asked, and the court did provide for them at the breakout room to try to work out some issues. And I'd like to first hear from it looks like this was that's set by the respondent. So let me hear from the attorney for the respondent with an announcement and then the petitioner.
Good morning. This is Brianna Griffin for respondent Cristina Alvarado.
Hello, Ms. Griffin. All right. And Mr. Lukowski?
Yes, Your Honor. Will Lahosky. I'm here for petitioner Gabriel Alvarado.
All right. Say your last name again.
It's Lahosky.
Lahosky. Thank you, sir. I appreciate that. All right, so we're here on a motion to compel. I believe that was filed by Ms. Griffin. Ms. Griffin, you all were in the breakout room. Were you able to work through most of your concerns, or do we have anything left for the court to make a decision on?
Your Honor, we were able to work through most of it.
Good.
Mr. Lahosky did send over some documents, but there was a previous hearing that stated if we didn't get specific documents or if those documents were not available, then we could move forward with a deposition. So the two of us, we did look at our schedules and agree to a deposition on June 10th, Your Honor.
Oh, that's very good. I'm glad to hear that. Are there any outstanding discovery issues, Ms. Griffin, for me to make a decision on?
Not at this time, Your Honor.
Yeah, good. Go ahead.
But I would like to call myself for attorney's fees.
Oh, for attorney's fees on this? Okay, very good. Please raise your right hand. Do you hereby solemnly swear you may proceed the testimony?
My name is Brianna Griffin. I have been licensed in dealing with family law cases in the state of Texas since 2017. I have the experience and ability to handle family law cases similar to this case. Back in 2023, Ms. Alvarado did hire Godwin Bowman PC, the firm I'm employed at, and agreed to my billable rate of $350 an hour, and also two paralegals, one at $150 an hour, the other one at $125 an hour. This motion to compel has been going on for some months now, and so I have spent 20.25 hours on this case. My one paralegal has spent 6.50 hours on this case, and another 0.75. That totals to 27.50 hours at a total amount of attorney's fees at $8,156.25. I do believe that myself and my staff hourly rate are reasonable and custom in the practice area. We do ask for a judgment for that amount and that it be paid within 2 weeks, Your Honor.
Do you have your billing records to introduce as an exhibit?
Yes, Your Honor. I do have one. Would you like me to show my screen?
Yes, I would, because I would like to have these billing records in place in the record. Your testimony is certainly helpful, but it's also helpful for us to have the billing records.
Judge, I don't see the ability to show my screen. Is it enabled?
All right, very good. So this is what I'm looking at is an itemized services bill showing some review of emails and some updates. Could you please scroll? Are these all the bills that you have pertaining to this case?
No, Your Honor, that's just pertaining to this matter. It does total up to this. There are some additional bills that are not in conjunction with the compel.
Do you seek to have this moved into evidence?
Yes, Your Honor.
Any objection, Mr. Lehowski?
Not necessarily to the exhibit. I mean, I have objections I want to offer as to the request, but not.
Well, in just a minute, but not the exhibit. Do you have any objection to the exhibit, Mr. Lehowski?
No, Your Honor.
All right. The exhibit, we're going to call it Respondent 1, is admitted. Please make sure that that's uploaded into Box for our court reporter to append to the hearing. Okay.
Yes,
all right. Anything else, Ms. Griffin, on attorney's fees?
No, Your Honor, that's it.
All right, very good. Mr. Lehowski, do you have any questions for this witness pertaining to attorney's fees?
Yes, Your Honor.
You may proceed.
So, respectfully, Ms. Griffin, I mean, why can't the attorney's fees issue be deferred until final trial, since final trial on all the issues in this case is just a couple weeks away?
Well, the most of the estate, Mr. Alvarado does have access to most of the estate. As of now, my client only gets $5,000 a month in spousal maintenance. She does not have the means to continue with attorney's fees. And we believe that since this motion to compel was brought not by you, Mr. Lehowski, his previous attorney, there were numerous requests for these documents. Thankfully, you did provide us with documents, but there were numerous requests before you got on the case. And so that did lead up to these attorney's fees being needed. And so, like I said, my client does not have the means to pay them. And so waiting till final trial will just put her more destitute.
I don't have any further questions, Your Honor.
All right. Thank you very much. I will award the fees in the amount, again, when it's
$56.25, Your Honor.
Okay, I will award that amount to Ms. Griffin. Ms. Griffin, please provide an order for the court to sign, and we will end along with the 2 weeks. All right, very good. If there's nothing else, Ms. Griffin, Mr. Lehowski?
Well, I did want to offer oral argument, Your Honor, against the award of the fees. I know you've just made the
just ruled. Yeah, just ruled. Yeah. What's the situation? I mean, they're entitled to them. There's a marriage here, right? Tell me what your situation here is, Mr. Lehowski.
Well, I've just been on the case for about a month, Your Honor, I believe. Okay. And my understanding is when she filed this motion back in February, Mr. Granger made a number of concerted efforts to provide a portion of the documents that were in dispute. And then I've thus satisfied all of those requests since I've come on the case. I mean, $8,000 seems like an awful lot for a compel hearing issue. I mean, she testified to 27 hours, and in my experience, the fees on these types of compel issues are normally reserved for final trial on the merits, because there's going to be voluminous claims presented by both sides, and we have a community pot that is subject to division. And really, her request today sounds more like a motion for interim fees and not necessarily just a motion for fees on a compel. And so I think this is something that should be deferred to final trial. We resolved the compel issues. We've agreed to a short deposition, and then we have the trial set, I believe, June 17th. And so that would be my request to my position.
Okay, what she's saying is that her client is financially unable to maintain this litigation with these fees hanging out there. I agree there's an interim fees element to this, but it's on a compel. And she was pretty careful to segregate those fees on the compel. Now, I understand it puts you in a difficult position because you're new on the case. Nonetheless, she has proven up the hours that she spent attempting to get these documents. And help me with this, why it's not just that.
And Judge, we did have other hearings about this matter. That's why I made it so many hours. Before Ms. Lahouty came in the case, there were previous hearings about the compel and deposition in those matters.
Tell me about those. Who heard those other matters?
Judge Arth, I believe, and
yes.
my understanding was the fees were denied on those previous hearings.
No, that's incorrect. I didn't produce any fees in front of Judge Arth. And actually, when we had a temporary orders hearing last year in November, fees were given to our office. That was for temporary orders. I have not requested fee. I did not request fees from Judge Arth on our last hearing, because the last hearing was strictly regarding an order being entered in the compel the deposition.
So, Ms. Griffin, were most of the on the compel, did most of this pertain to things that happened while Mr. Granger was the attorney or while Mr. Lahowski was the attorney?
Mr. Granger, Your Honor.
So since Mr. Lahowski has come in, I mean,
I do understand Mr. Lahowski is in a difficult situation, but my client is also, Your Honor. Like I said, he has been complying. We have been conferring and getting some things resolved, but before then we were unable to. And the compel has been going on for months, or at least the issue about these documents have been going on for months.
Well, but Your Honor, her motion that's before the court has only been on file since February. And
that's kind of
she's talking about,
we're almost in June now. So
I know, but she's talking about hearings that happened prior to her filing the February motion, not hearings since that date, I don't believe. And this order for attorney's fees from Judge R, that was in December of 2023. And so again, I mean, it's like she's pointing to efforts to accomplish other relief for her client in other motions that are separate and apart from the compel that she's seeking fees on.
No, I just was explaining to you, because you weren't on the case, that there weren't any fees requested at the last hearing. The last time I requested fees was back in for the temporary orders hearing. I did not request any at the last motion for continuance / enforce the deposition hearing.
So if that's the case, then how is it that she preserves her right to request fees for prior hearings when she didn't request fees at the time she went forward on the requested relief before? That doesn't make any sense to me.
Because all of it pertains to the compel of the compelling of these documents.
What type of documents are we talking about, Ms. Griffin, that you couldn't get your hands on?
Employment documents, Your Honor. More specifically, he's not paid like a regular salary. He's paid like he's in tech sales. And so his pay differs based off different deals that he does. And so we wanted a breakdown of those deals to determine the amount of money that he was paid throughout the marriage to consider what was community property. Previously, we didn't get any documents. We actually only got a screenshot of 2 lines before Mr. Lahowski came on the case. We didn't get any documents regarding his pay. We actually didn't even get his tax documents until the most last hearing. So we didn't have any detailed information on his pay. All we had was his base salary. His base salary was way lower than what a check stub that we had.
That's pretty basic, Mr. Lahowski. I mean, if they can't even get that, that sounds pretty basic to me.
Well, and again, since I've been on the case, Your Honor, I've provided everything that they've requested. And I've worked with Ms. Griffin to try to resolve any deficiencies, because we want to try to work towards an agreement, and we want them to have all the information that they need so that we can have our best opportunity to reach an agreement. And that has been my sole focus, to try to accomplish this. And before her testimony today, I wasn't aware that she was requesting this amount in fees. I thought that we were down to a sole issue where she needed one document, which I've since provided. And now I'm being told she needs $8,000 in attorney's fees to go forward. And it seems to me there's a legitimate dispute on how much was actually incurred to achieve what she needed to go forward today versus other issues that were before the court and that were previously ruled on before I came on. And again, I think that speaks to the reason why this needs to be dealt with at the final trial, because there's going to be arguments back and forth on who's requesting what.
Well, it does sound like, I mean, I will say this in her favor. These are pretty basic things she's requesting, and she couldn't get them. I understand you weren't on the case, and that's an issue. On your side, Mr. Lahowski, if you didn't realize this was still an issue that was out there, you thought everything was done, that I think does weigh pretty heavily in your favor right there. So I'm going to go with you, Mr. Lahowski. Request for fees. Please take it up at the next hearing with the trial judge. It's coming up. It's denied. It's denied. Nope, it's denied without prejudice today. But you may bring it up with the trial judge. Mr. Lahowski, please draft an order and circulate it. All right, you may.
There's a request in our motion.
You're done. You're done for the day. Thank you both. You may have a wonderful rest of the day. You may be excused. Please, Mr. Lahowski, send an order to me. All right. Thank you. Goodbye.
Thank you, Your Honor.
Looks like we've got. All right. All right. So we had a final case on our morning docket, which is Jediah Jones versus Dejanay Harris. We were here on a merit sapsir, which was set for 2 hours. I understood the parties were in the process of reaching an agreement. Let's see, this was set by the respondent. May I please have an announcement by the attorney for the respondent?
Aisha Denis for respondent Dejanay Harris.
All right, Ms. Denis. And who is here on behalf of the petitioner?
Mr. Jones is currently representing himself, but I do believe we were very, very close. We had one last issue regarding the child's last name. If the court has time, would you be able to give us some insight on what your preference would be if that was presented?
Ms. Lovelace, what's your role here?
Guardian ad litem.
All right, thank you very much. All right, so what's the issue on the child's last name? Ms. Denis.
Yes, so we are discussing adding Mr. Jones's last name, hyphenating it. It's my understanding that Ms. Harris would like to leave that option to the child as she ages. She wants to change her last name from Harris to either both or one or the other. And Mr. Jones, correct me if I'm wrong, he believes that it's easier to start with both names and then decide to drop one later. And so that's kind of where we're at. And we're just wanting to see.
Okay. How old is the child, Ms. Denis?
She's 2.
2. Well, I will say, I think that it's, here's what I think. I think that children in our community, maybe it's because women give birth, I don't know. It seems like there is more of a bond to the mother. Therefore, children also, just because we're a patrilineal society, they often carry their father's last name. Which in this case would be Jones. I have noticed, and there's a trend now in my own family. Is part of this trend. At first, it would give the mother's name as a middle name, but now it seems that the mother's and father's names are often hyphenated. And these names are pretty straightforward. Harris Jones. These are pretty straightforward names. They're not difficult to spell. So my thought would be to go with the hyphenated, and as the child gets older, the child can take the name they want or keep them hyphenated. And my kids have hyphenated last names. They're very complicated ones, and I sometimes don't know why they don't change them, but they like them. They like them. So I think that it's maybe just my thought on this would be, since you all can't agree, to hyphenate the name. And then if the child wants to drop one later, that's fine. But at least what it does, and I think this is in the interest of the child, is it gives the child a connection to father. And father and the child would at least have the last name. And it's less likely for him to get kind of cut out of the picture And I really think that children are well served if they've got their father in their life. So my thought would be hyphenate these names. Okay. Now, if the child gets older and decides, I don't want to do that anymore, that's fine. The Travis County Law Library will, for free, no matter what someone's income is, help you with a name change order. So it's possible that if the child gets to be 14 or something and says, I don't really want both of these names anymore. Honestly, I kind of doubt they're going to do that. I think they're going to like having both names. But if they do, they can go to the Travis County Law Library and file a name change order without any charge to them. The attorneys there will help them file it, and then we can go with one or the other. But I don't know. I think it's kind of nice for kids to have parents both last names. You see that in some of the Latin countries, Spain, Italy, things like that. You see the hyphenated last names more frequently than you do. But even in Great Britain, you see hyphenated names quite a bit. You know, it's you do see that. So I'm going to go with the hyphenated here, Ms. Dale. Okay. Anything else?
I believe that was our final small issue. I think we've solidified our agreement.
Okay.
And we can present an order. Oh, I don't know if you would like us to detail that agreement.
Yes, please get it into an order and send it to the court. When can you get it to me by, Ms. Denny?
We should be able to get it this afternoon.
Okay.
The majority of the order was already drafted, and then the edits that we've made today can be added pretty quickly.
That would be wonderful. Send it, if you would, send it to 455.submission@traviscountytx.gov. Again, 455.submission@traviscountytx.gov. And in the subject line, put HO in the clause number and the parties' names. And that way, when it comes through, Ms. Guardiola will see it, because that is our submission docket. We get quite a few documents through there, and we try to process them all within a couple of days of getting them, but we do obviously we push those hearing orders to the front of the line. I'll sign it, date it, and then send it out to you. And then the district clerk's office will send it to everyone whose email address she has. And you'll have a copy of that order with with all this, with these terms included in them. Okay.
All right. Mr. Jones, is there anything additional?
Yes. And then the birth certificate situation.
Yes, so we will add, we discussed making sure that the birth certificate the paperwork to update the birth certificate will be completed this afternoon as well with the order.
Okay. That's
okay.
Good. All right. Okay, well, let's go on and get that order done while everyone is feeling good and on the same page, and I'll get it signed and get it back out to you. We will expect it by 5 o'clock today. Okay.
All right. Thank you, Your Honor.
Right. Thank you, Ms. Denny, Mr. Jones, Ms. Harris, Ms. Lovelace, Mr. Jones, and Ms. Harris. I do wish you all the very best now that we've got these issues resolved. And I encourage you to always be there for the child and always do things in the child's best interest. You will never regret one moment of something that you've done in the child's best interest. When you were there for that child and that child knows they can rely on you, you will never regret those moments. All right. Very good. You all may be excused.
Thank you, Your Honor. Have a good day.
1696. This is a 2.6 assignment case, although this court is currently on the family docket, since it's been specially assigned. We are here with you on a civil case. We were here on a motion. I must admit, I've never seen a motion entitled this before. It is, or heard of one in my, over 30 years of litigation. Prior to taking the bench, we're here on a cross motion to enforce the local rules. So who set this motion?
Your Honor, I set this motion, Matthew Zorn, for defendants Hildreth, Symposia, Psychedelics Today.
All right. Very good. Who else is here on behalf of defendants? Okay, who's here on behalf of plaintiff?
Me, Your Honor. George Greg Lake.
Okay. All right, Mr. Lake.
Your Honor. I'm sorry, Your Honor. Greg Noche and Liza Eoff for the USANA Promega defendants.
All right, so I'm trying to figure out, are you and Mr. Zorn, are there different defendants here, Mr. Zorn, that you're representing? And then we've got the USANA Promega defendants.
There are two different groups of defendants, Your Honor, and I'm happy to explain the difference and maybe giving the court a little bit of an orientation about the case before I explain the motion and the necessity for the motion in this case.
Yeah, that might be helpful. I must say, joint motion to enforce the local rule is a little unusual, as you all can imagine. So let me hear from you, Mr. Zorn.
Yes, Your Honor. It's an unfortunate motion, and I think it would be helpful if I just orient the court a bit about what this case is about, and then I will get into the substance of the motion. And so in many respects, this is probably going to be a standard fair Texas citizens participation or TCPA case. From our viewpoint, this is a case about plaintiffs' attempt to retaliate against all of the defendants for exercising free speech rights, and in particular, alerting to the public to a possible public health risk and frankly fraud, Your Honor. And there are some unusual facts to this case. There are two groups of defendants in this case. So there are the Usona Promega defendants, and then there are the republisher defendants. And I'll explain the difference in just a moment, but I'm here representing the republisher defendants, comprised of journalists, scientists, and social media personalities. Here's the gist of the case. The plaintiff, the Church of Sacred Synthesis, says it has a sacrament that has a molecule in it called silomethoxin that it distributes to its members and that its members use religiously. The church not only makes this substance and distributes its sacrament to its members, but it also offers the sacrament for sale on a website. In a marketplace, for example, at thesacredsynthesis.com/marketplace, you can buy a sacrament bundle for $145. You can buy 30 sacrament capsules for $100. Or you can buy a chocolate bar that has some sacrament in it for $65. A couple weeks ago, the church had a Memorial Day sale where you could get sacrament for 15 or 20% off. Now, what this case is about is the Usona and Promega defendants obtained one sample of the so-called sacrament. They tested it, and they did not find any silomethoxin in it. Instead, they found psilocybin, which is the active constituent in magic mushrooms, which are controlled substances, Schedule I, under both federal and Texas law, which means they're illegal to possess, use, consume, and so forth. Then the Usona Promega defendants published an article on the testing that they did, explaining the results to the public. And I would just alert Your Honor, nobody that's tested the sacrament has, with any level of scientific rigor, has found any silomethoxin in the sacrament at any point in time. And I need not belabor this point. Basically, in certain respects, by all credible proof, the church is selling magic mushrooms online. Now, in the case of the Promega Usona defendants, it studied the sample and published that result in a scientific journal online. Some of the other Promega Usona defendants, including Promega itself and its CEO, appear to have absolutely nothing to do with this case and were simply brought in by plaintiffs for reasons I cannot explain. In the case of my clients, the republishing defendants, they essentially wrote articles or commented on the Usona Promega. It's not even Usona Promega. It was just an article written by two of the defendants in that group. And so their acts range from basic journalism to opinion and criticism, calling into question the church's practice. And so very shortly, Your Honor, the defendants will be filing a Texas Citizens Participation Act motion asking this court to dismiss the case because, among other glaring deficiencies in plaintiff's case, there's no credible evidence, let alone clear and specific evidence, to substantiate the existence of silomethoxin in their sacrament. In fact, if you were to go to the Wikipedia page today, it would call that molecule hypothetical. Now, that intro is just to orient this court to some of the unusual facts of this case. And now I want to talk about the unusual motion that I brought to this court, because over the past several months, it's become clear to us that plaintiffs and their counsel have expressed an unwillingness to abide by unambiguous rules. And then when we bring that to their attention, they concoct reasons ranging from unreasonable readings of the rules to no harm, no foul for why the rules don't apply to them. So the present motion has to do with pre-motion conferences. Plaintiffs didn't confer with defendants before filing the motion. And to be sure, I discussed with plaintiffs' counsel the subject of the motion, which was a motion for substituted service, because I told plaintiffs' counsel that we would agree to waive service days before they filed the motion. And so there was resolution of the issue. And I said, just give me a couple days, I will get the papers in. Your Honor, I had 2 depositions in very large matters and had the affidavit right in front of me and I was ready to file it And plaintiffs went ahead and filed their motion anyway, saying nothing of the fact that we agreed to waive service. And then in subsequent correspondence simply misrepresented what had happened between the parties. And then in their response, the court can see that their interpretation of Rule 2.2 is that pre-motion conferences only need to happen after a hearing is set on a motion, which is completely contrary to the text of the rule, which says that all non-dispositive motions require a certification that the parties have conferred. And the reason why is fairly straightforward, which is to avoid having to bring needless motions to the court. And I should note, Your Honor, that plaintiff's motion was sort of the archetype of a needless motion because, again, we agreed to waive service, so there was no need for substituted service. Now, that isn't the only reason why we have brought that to the court, because this is not proving to be an isolated incident. In fact, there are more serious violations of rules that we have put in our reply brief that I think it's important for the court to know. One of them is plaintiffs insist in their response that my clients weren't officially represented. That's a phrase in the response by me, even though I expressly told their counsel orally and in writing that I represented them, two of the defendants. Knowing that my clients were represented by me, plaintiff's counsel contacted my clients directly without copying me on the correspondence. Plaintiff's counsel knew they were represented by me because I told him, and they went behind my back and talked to my clients in an email. More concerning, in effect, it is as part of what appears to be a fact-gathering operation to complete service, plaintiff's counsel impersonated a fake individual and contacted the USONA, one of the USONA defendants, USONA. And this is beyond dispute, Your Honor, because there's a recorded voicemail of plaintiff's counsel purporting to be a person named G, contacting them to, I don't even, to donate money to them. But this was one day after plaintiffs sent a demand letter to USONA. Plaintiff's counsel calls impersonating an individual named G, and then also sends a written communication where plaintiff's counsel purports to be a Roger Growing, and then sends contact information with an email that plaintiff's counsel's email. And that's in our reply brief. It's in a footnote. And then when we confronted plaintiff's counsel with, frankly, these unimpeachable facts, plaintiff's counsel floated conspiracy theories like his phone being hacked, and then simply stated he never misidentified himself, even though it's pretty clear that he did. And finally, there's now a motion on the docket for protective order. Plaintiffs seek discovery of a third party to get information on my anonymous client who offered criticism anonymously and wants nothing to do with this case or plaintiff's enterprise. I have no idea why. He's a small-scale social media personality, and he doesn't want to be publicly associated with this case. And most importantly, I told plaintiffs we'd be willing to waive service if we could maintain his anonymity through the opening of discovery, and plaintiffs refused. So I have strong suspicion that plaintiffs have included him for improper purposes in this case. Suffice to say, plaintiffs aren't entitled to discovery before third-party discovery before the discovery period opens, and yet it's another instance of plaintiffs believing that the rules don't apply to them. So in sum, that's what this motion is about, and it's an unfortunate motion, but it's one that is a plaintiff's unwillingness to abide by clear rules is starting to cause serious harm to people in this case already before it even gets off the ground. And so, at this juncture, what we're asking is, going into this next phase of the case, at this juncture, we're asking for a court order that the procedural rules, that the parties need to abide by the procedural rules, because whatever their religious beliefs may be, belief is not a basis to not follow the rules. Like, the plaintiffs need to follow the rules, and so do we, and that is the purpose of today's motion.
All right, thank you very much, Mr. Zorn. Mr. Noskazi, did I say that correctly?
Actually, Your Honor, you did in terms of the Italian pronunciation, but our pronunciation in our family has changed over the years, and it's Noche.
Noche, all right.
Yes, thank you.
Well, I'm glad at least I got the Italian pronunciation correct.
That is correct.
Mr. Noche, what do you have to add to what Mr. Zorn has provided, if anything?
Miss Eoff is going to address that, Your Honor.
All right, Ms. Eoff, what else do you have to add to what Mr. Zorn has just presented?
Mr. Zorn has adequately explained what has happened with respect to our clients. We do have a motion on file to stay discovery because the discovery period has not opened. I can confirm that we explained the rules several times to Mr. Lake, and I believe he just had an outdated copy of the rules, and that's why there was some confusion. And so we're here to verify that what Mr. Zorn has correct as far as what's been going on, but this is his motion.
Thank you very much. All right, Mr. Lake, please unmute yourself and let me hear your views, okay?
Yeah, thank you, Judge. And I guess if you don't mind if I start out giving a little bit of our side of the background, leading up to this case and kind of what this case is about, and then briefly address these local rule alleged violations. I'm an attorney in Texas, and another attorney in Texas is a good friend of mine, and we are what we would call entheogen-based religious practitioners. We claim protection under the Federal Religious Freedom and Restoration Act of 1993 and the First Amendment, and also the Texas Freedom and Restoration Act, I believe, of 1999, which provides commensurate, and if you ask the Fifth Circuit, in some cases, possibly more protection than the federal counterpart. But anyways, we ran across, and my partner had been on a very long spiritual journey to find a molecule like silomethoxin, and he came across some literature from a very respected but not with us anymore chemist named God, his name Shulgin, Alexander Shulgin. Anyways, Alexander Shulgin proposed if you put on a cow patty with hallucinogenic psilocybin mushroom substrate growing in it, 5-MeO DMT, 5-methyloxyl dimethyltryptamine, which are both, these are all three together are controlled substances. Silomethoxin is not a controlled substance. Now there are residual amounts of psilocybin and psilocin left over in our sacrament. Now, when we first began our church way back in 2020, we did not immediately open it up to the public. We actually went and served a little bit over 1,200 people who all gave the same feedback. No negative health reactions. That was our main concern. And then two, that there was a absolutely unique effects profile from these mushrooms from any other mushrooms that these very experienced people have created. So in September 2022, we decided we went public with the church. Despite now, yes, it is a lot easier to get sacrament from our church, but that is more or less a function of what has been caused by these defendants. Within September through April of 2023, we saw significant growth. And I don't know if that upset the USONA defendants or how we came on their radar or of any degree, but we had been making strides because part of my clients, the church's liturgy, is this idea that science and religion and spirit are not neatly compartmentalized things, and that, especially through the study of psychedelics, we're starting to realize that, these two things overlap in many ways that we don't quite understand. And so it's part of our religious practice to further understand the interrelationship between those two types of dichotomies. And so, yeah, so anyways, our plan was, once we get up and running, we get membership in. We had about 2,000 members whenever this happened. We were doing really well. We were bringing in almost $100,000 a month in membership fees and sacrament sales. And, but at that time, we had not had enough money to save up to get our own testing facility, because as you can see from what's happened in this case, you can't just go to any willy-nilly person and ask for a test, to test your stuff and trust that what they're going to come out with is truthful. And what we found out probably about 2 months before suit was filed here was that if you test our sacrament with water, unlike methanol that USONA Promega did, again, and Matt was right. This is kind of there is no reference sample currently existing for this molecule, but USONA did make a guess at what the weight would be. And when we tested our sacrament with water, consistently every time we're pulling up a molecule with that exact same weight. And so we are in the process of creating the NMR reference sample to absolutely confirm 100% that there is silomethoxam in our sacrament. And I will say this before I turn to the just real quick and address the local rules, is that I have a billionaire client that is in Nebraska that was invited to USONA Promega facility and was told some things that seemed to indicate that they knew before they published this article that that they knew that this was not the 100% truth. But we will prove that in court. Don't take my word for that. That's just something I'm throwing out there. But with that being said, look, on the local rules, I did maritime litigation in Louisiana for close to 4 to 5 years before I completely switched over to doing this. I had never had to single-handedly deal with so many defendants at one time to try to get them served in such a short timeline, like a defamation claim with a 1-year statute of limitations. I did the best I could. I thought that I was really just following through with my due diligence. With Mr. Zorn, I've known Mr. Zorn. We've had a prior relationship, and I consider us to be friends. And he just, it kept saying one day, give me a couple more days. We're going to get this. And there's a lot of republishers here. So, his claim to represent all the republishers. But if you ask him one day if he represents Gordo Tech, and if I can get, instead of having to subpoena, a Patreon to get his anonymous information, I will be filing a motion very soon because I just amended my Second Amendment petition to basically include constitutionally sufficient evidence to create a prima facie case against Gordo Tech that would basically give you the green light to give a order to compel Patreon to disclose to me, regardless of when the discovery period starts, because this is a third party. I'm not even really sure how applicable this new third party rule, and I was mistaken at first, and I do apologize to everyone on the USONA side for being mistaken about the rule. I had an old version of O'Connor's, and I wasn't aware of the new amendments that had taken place. But now I am very well aware and ready to proceed that way. Lastly, I do. Unfortunately, this has caused me a lot of stress. My normal work plus taking on this litigation. And I had a couple seizures over the course of about 3 weeks. And I honestly do not remember placing these 2 phone calls to USONA. My wife tells me that I did make the one with and identified myself as G. Why I did that, where I was mentally when I did that, I do not know. I apologize. It will never happen again. As far as the other one is identifying myself as a Roderick or Roger or something, I don't have any record of it. My wife does not seem to recall me making that phone call. But she did hear me call them, and what we were doing, we're seeking better service information to get them served. Is what was the cause of the matter.
All right, very good. Thank you, Mr. Lake.
Yes, ma'am.
All right, so I've heard now from Mr. Zorn with the republisher defendant. I've talked with Ms. Eoff, who says that she is going to rely on the arguments made by Mr. Zorn at this time. I realize there's some other motions, but they aren't set today. And I've had the opportunity to hear from Mr. Lake, who, are you currently licensed in Texas, or are you pro se?
I'm currently licensed in Texas, and I will say, due to my physical ailments, we have been able to, I think by the end of this week, we'll have a firm out of San Antonio basically taking lead counsel for us in this, because there might be a chance I might have to be a witness. So, you know,
Right.
in case that chance comes, we'll have someone there who can take and, you know, there won't be any issue and we can keep this thing going smoothly.
Mr. Lake, I would strongly recommend that. I think it's very difficult to represent an entity that you have strong beliefs about.
It is.
It's hard to keep your emotions out of it, and that can really sometimes not benefit a party in the courtroom. So I would encourage you to get that law firm that you mentioned, or any reputable firm, to help you with the case. So
Yes.
today we have to take what we've got. All right, so Mr. Zorn, let's go back to you. So it looks to me like what you're asking me to do is to sign an order that says follow local rules, which are basically already an order. Is that what you're wanting? I mean, or is it more the type of thing where you need me to hold them in contempt? I guess that's the question. What do you want from me today?
Your Honor, we do not want an order, a contempt order today.
All right.
The operative word being today, that is not what we want. We do not want sanctions. We do not want any affirmative punishment today. But we do believe a court order saying that the parties need to abide by the local rules would then be a court order, and then going forward, the parties would need to adhere to the rules and maybe if it continues. Again, a very unusual motion, but as I've narrated to the court, there have been some serious events that frankly just need to stop. My clients cannot be contacted by Mr. Lake without going through me when he knows them to be represented. That is my main concern at this juncture. And so, and similarly with the procedural rules, it can't going forward. It can't be the rules don't apply to us. So that's all we're requesting today is a court order saying that the local rules apply to everyone, and going forward, there could be contempt penalties.
Yeah. Well, of course they do apply to everyone. They already apply to everyone. I can't really issue an advisory opinion, you know?
Well, then, Your Honor, we would ask that simply the court note that the local rule was violated in this case, but we are not asking for a penalty or a sanction of any kind. Right. The motion was resolved successfully, but we would like a finding that the local rule was violated because plaintiffs did not confer on the motion.
All right, so I can't issue an order that says in the future follow the local rules. That's already the rule. Now, what he's saying, Mr. Lake, and when I ask him about contempt, and I think Mr. Zorn is trying to keep he's trying to pour water on this fire rather than gasoline, which I do appreciate very much. I wish that more people would come into court with that attitude. That typically those local rules they already have the force of a court order, and if you violate them, you violate them. And so, if you continue to violate them, they can come in and on a motion for contempt, which can include fines and jail time. And I know those are things you don't want because it would take you away from the Church of Sacred Synthesis, and that's what you do not want. So, but Mr. Zorn has pulled that punch, as they say. He's not going to do that. I cannot I can't sign an order that says in the future, follow the local rules, because that doesn't add anything. It's advisory in nature. Mr. Zorn, if you want to draft an order that says there has been a violation of the local rule, and I find it, the parties are not currently seeking contempt or monetary sanction, I would sign an order like that, but be specific on how it was violated. Okay?
Thank you, Your Honor.
All right, so I'm going to go on and grant relief to Mr. Zorn today. Mr. Lake, though, please keep in mind, this is, as we used to say, it's a shot over the bow, meaning it's kind of a warning. It's a warning volley that's saying to you, you got it. I understand what you're saying. You've had certainly some very serious health issues, it sounds like to me, and I hope those are resolved. Seizures. I'm concerned about your well-being with that, sir. I know you have had experience practicing maritime law in Louisiana, as you've explained to me. And I know that you're in the process of looking for a law firm to handle the case. I really suggest you do that, because the thing is this, Mr. Zorn, if he hadn't come in and just fired the shot over the bow, he could have made you all pay some attorney's fees. And I know you want that money for the church. And he could have come in here and held you in some personal contempt. And that would take, not only are you a person with some health issues, but you're also, as you've pointed out to me, extremely busy with your church and this litigation. The last thing you need is for us to impose some sort of jail time for violating local rules. Now, I'm not saying we would do that, but it's in basket of the toolbox that we have for these types of things. So let's take Mr. Zorn at his word. He's going to draft an order saying that there was a violation of the local rules. He's going to explain it in the order. He's going to say that there's no contempt being sought and no attorney's fees. I'm going to sign that. But Mr. Lake, please, in the future, just review those local rules. They're online. They're very easy to find. So just find those Travis County local rules and read them and abide by them. Do not contact people. I know you said you don't remember it, and I'm going to take you at your word on that. But if your wife hears you picking up that telephone when you're in an altered state of mind because of health issues or what have you, please say the court has ordered me not to do that. You all figure out a way for her to nicely ask you to not make that phone call and to wait till your head is cleared. And then I want you to contact these attorneys directly, not the clients. Okay?
It was my fault, Your Honor. I the statute of limitations was running up real quick. Okay. And I was just impressing upon her how, we need to get this filed and served ASAP, like just ASAP. Mm-hmm. And, even she was kind of getting a little bit frustrated with Mr. Zorn a little bit whenever he was kind of going back and forth a little bit. And she was like, just follow the motion, and I think we all learned a little bit now that, if Mr. Zorn tells me that he's representing somebody, even though they haven't been quite served yet and it's past the statute of limitations, I guess I just got to kind of rely on what he says.
Well, the filed and served, I mean, I don't want to tell you how to do your lawsuit, but I think, if you got it filed in a timely fashion and served within a reasonable time, you're probably okay. But I have not looked at the statute that applies to you. So right. You need to get, too wound up on that. Now, here's what I'm going to ask you, Mr. Lake. I hear what you're saying. Please, when we get off this call, go online and find the Travis County local rules and read them. In fact, Ms. Guardiola, is it possible for us to put, or Mr. Agidi, possible for us to put a link to those rules in the chat box so that we don't have this come up again?
I've got them right. I was reading them prior to our hearing today, Judge. Good. I'm going to become an expert on them by the litigation.
That's what I like to hear. All right, so let's do that. And again, tell your wife, if you start to see me when I've had one of these, bad health spells with seizures or whatnot, please don't let me make those silly phone calls to people who are represented. You need to, those calls, all of them now, you need to go directly to Mr. Zorn or to the other attorneys on this call if it pertains to them. Represented people cannot be contacted directly. That's why we have to have it with the attorneys. Okay. All right. And when you have someone call up and say, hey, can we make an agreement? If you're amenable to that agreement, which the rules require you to do that first, then that's done. That's a done deal. All right. We don't go back on that. So, all right, folks, I don't know if there's anything else I can do for you, Mr. Zorn. Please draft that order. Do not make it advisory in nature. And I will sign it and send it to Mr. Lake. And Mr. Lake, you put that right where your wife can see it. And you say, look, that judge said this is a shot over the bow. In the future, we've got to be a lot more careful, or we could end up having to pay attorney's fees. We could end up being fined. Bad enough violation, we could even end up in jail. And that takes you away from your duties with the church. And that's what you don't want. Okay?
The attorneys we spoke with, real quick, Judge, the attorneys we spoke with real quick yesterday, they were just blessed that we have one judge through this whole thing. They said, look, because I like to research and write. I'm a First Amendment expert, and I like to research and write on First Amendment stuff. So, all I'm going to be doing from now on is just sitting back, research, writing, doing some depots and some discovery, and only talking to the parties with their attorney present.
All right, that sounds good. And to the degree that you can take on more of an assistive research role than being the face of the litigation, in other words, at depositions and things like that, I would really encourage you not to do that. I think when we have to show up as attorneys asking questions in court or in deposition, because as we always say in deposition, it's just as if the judge and jury are right there when that's occurring. To the degree that you can step away and hand off those duties to the San Antonio law firm you mentioned, I think that you're going to find that your time here is a lot easier and that we won't have Mr. Zorn, Mr. Nosage, and Ms. Eoff bringing you into court on this stuff. So, but I understand it. As you've made very clear, you have a high degree of expertise in these areas, and I have no doubt that you will be research and writing. I just kind of let that law firm take the lead in court and any kind of witness or deposition. Okay. The other thing, Mr. Lake, I want you to be aware, it looks like there is going to be a motion filed potentially by Mr. Zorn, kind of questioning the underpinning of this lawsuit. That's something he's entitled to do. The other thing I want you to be aware of is you might get some disclosure requirements. Please look at the, Texas Rules of Civil Procedure on Disclosures.
Okay.
If you get discovery coming in, please look at those discovery rules. Now, sometimes in discovery, they ask us to turn over things that we do not want to turn over. The law still requires you to get those at least to your attorney. Make sure that no matter what happens, that you put a number at the bottom of every single page, sequentially from the first page all the way through to page 1000. We used to call them Bates numbers, but we don't call them. They're just numbers, sequential numbers. And that when you respond to that discovery, that you write in response, for instance, C page numbers 0005 through 00025.
Okay.
If you do that, it'll make things a whole lot easier. If you just, I have a big pile of cases on my desk, but if this were a batch of discovery and I just stuck all this in an envelope and sent it to them, that's too hard to deal with. And that's not what the rules require. So on the bottom of each page, put it in your Adobe program. It'll put a number on it. And then when you respond to those questions, make sure to put that number in there. Now, when we hang up this call, thank you for looking at the Travis County local rules. Go look at the rules on disclosures, request for production, and interrogatories and depositions. Familiarize yourself with those. If for some reason the San Antonio firm does come in, you'll have more productive discussions with them. If they don't come in, then we hopefully won't end up here again on a motion that honestly we didn't really need to come in. Okay? All right, Mr. Lake.
99% they'll be coming in. So we'll hopefully by the end of this week, next week, have them as counsel, and we can just.
Okay, have them make an appearance so I can see them when they come in.
I will.
All right, very good. All right, Mr. Zorn, anything else?
No, Your Honor. Thank you very much. We appreciate the hearing.
You're welcome, Mr. Nosage. Anything else?
Nothing from us, Your Honor. Thank you.
Mr. EF, Ms. EF, anything else?
No, Your Honor. Thank you for your time.
All right, you're welcome. All right, thank you all. It's good to see all of you. I wish you a very happy rest of the day, and we'll look forward to seeing you again in the future. You may be excused, okay?
Been a pleasure seeing y'all today. Thank y'all.